Any mention?
Yes.
Wait, please, Your Lordship. Lordship, I beg to mention item number 25.
Model Islam. Who's for the petitioner?
I am for the petitioner, Your Lordship.
23.
25, Lordship.
25, yes.
Lordship, since the conducting counsel is
Yes.
not here, so
After 1 week.
Yes, 2 weeks, Lordship.
2 weeks, okay. He's on operation, yes.
Lordship, I have a similar prayer for item 21.
oblige, Your Lordship.
21.
The consent of the petitioner counsel is
Have you
already
informed? You have informed the.
Yes, Lordship, I have already.
Yes. 2 weeks, yes. Yes.
Lordship, and item 15 and 16, these are connected.
My lord, I inform the petitioner in item number 15 and 16, my lord.
Yes, after 2 weeks. Yes.
My lord. Detail, lord.
Lordship, I have a similar prayer for item 17. I'm the petitioner in this matter, Lordship.
Where's the respondent? Other objection, 2 weeks, yes. He's recovered now? He's in the hospital?
Still in hospital, Lordship.
Okay, yes.
Highly obliged, Lordship.
Your Lordship, I beg to mention item number 20 on behalf of Mr. A. Khan, Your Lordship. He's still indisposed.
20.
Yes, Your Lordship.
A. Khan.
A. Khan, Your Lordship.
How many lawyers are appearing for the state here? The private respondents also?
Yes, Your Lordship, they are private respondents.
No objection. 2 weeks, okay.
Obliged, Your Lordship.
Yes. Yes, followed.
May I please, Your Lordship? Your Lordship, I beg to mention item number 24 on behalf of Ms. N.G. Shilla.
What happened?
She's on leave, Your Lordship. She's not available.
No objection, Lordship.
Pichi Sangma, 2 weeks.
Obliged, Lordship.
Or 1 week? 1 week, yes.
Which was reviewed item number 22, my lord. In for 1 week time.
22?
I've been informed them.
And for the private respondents, 8 to 12 months.
What state? Yeah, there. 2 weeks, yes. Follow. Where's Mr. Gautam?
We haven't prepared, Your
Don't
Lordship.
say you haven't prepared. 1 week, you did. Otherwise, next date, no for your adjournment, yes.
Deeply obliged.
22 matter, yes.
Please, Your Lordship, I beg to mention item 13.
Number?
13, Lordship.
Why? What's the reason?
Lordship, we
Just
have
like that.
obtained.
You ready for the matter?
My lord, the last
Your
occasion,
objection?
my lord.
Your
Because on,
objections?
yes, my lord.
Because
Because
the
on the
matter we
last,
called out, then you tell me your senior.
Lordship, we have obtained instruction that there was ongoing talk of settlement, but there was after this ongoing talk, there was no possibility of settlement. So
When
I
his
bring
senior
for
come,
2 weeks to.
He's objecting to it.
Lordship, bring for some accommodation, Lordship. The senior counsel is having.
Senior is not here.
He's here, Lordship, but he's having a part-heard matter.
What to do?
Bring
Your
for 2 weeks
objection?
time,
Is there
Lordship.
any settlement talk going on?
nothing,
No.
my lord. And the last occasion also,
Tell
my
Mr.
lord,
Secretary to come. Yes. We won't take up the matter, we'll just find out what's happening, yes. Yes.
Supplementary list, item number 1.
Dr. Todi, this is not this is one supplementary list. Your matter on the main list, I think.
My lord.
We're taking up supplementary list first. Motion.
Yes, my lord.
Yes.
May it please, Lordship. Lordship, I am paying this matter, my Lord, next week because we have forgotten to annex matter two documents here.
Then you have to withdraw it and file afresh. How can you just ask permission to
No,
annex
my Lord,
documents?
here what has happened, my Lord. We have annexed the CIS report, my Lord, the status report of the case. My Lord, just need to include the applications, my Lord.
The?
Applications, my Lord.
Then that you can't. Will it materially affect the contents of the petition?
It will not, my Lord. It will not, my Lord.
Yes?
Your Lordship, actually this is a petition where they are seeking for direction to the lower court
to dispose of the matter within a period of 1 month, Your Lordship.
2 applications, my lord.
I do not see anything. They have just
How did it
attached
really
a
affect-
list of dates.
How did it affect the case?
Lordship, here-
What's your prayer here?
My lord, expeditious disposal of the 2 applications, my lord, 2 miscases, my lord, which we have filed along with
That
the
has
title suit,
not
my
been
lord.
attached.
My lord, we have given the status report of the, my lord, the CI has generated copy of the status report, my lord. We are filing the cause of
Only
debt.
been filed accepted. You can't change it. You have to,
My
you have
lord,
to withdraw it and file afresh. Mr. Panti, it's already become it's part of the record now.
If I may pray, my lord, why? Because this will not change the nature of the
No,
petition, my
even
lord.
then,
Otherwise, also,
it has to come by formal application. Then most amendment of the petition. There's civil revision also.
but
Those
You
are
file it afresh.
important documents, Your Lordship.
Yes, it's important document. Yes, Mr. Panti, subject to some defects, he prays allowed to withdraw the instant application with liberty to file afresh.
obligation.
Prays allowed. Matters transposed with order to draw liberty as prayed. Yes.
Item number 2.
This pertains to non-payment of salary, my lord. The petitioner was appointed as a head teacher in Lumsarthum SSLP school, my lord, in the year 2004.
Yeah,
2004, my lord.
2004. Then what happened?
Since
Where's
then,
the appointment order?
appointment order, my lord, she don't have the appointment order.
Then how's she working?
My lord, her name is recorded in that UDICE, my lord. It is there, my lord. My lord, may kindly see page 50,
1-5.
50, my lord.
Where's the name?
My lord, 7 column, my lord. Genesima pin group. Date of joining
Then you
13
was
to
working since
2004.
2004, only
My lord,
payment.
nothing has been paid to me.
How do you survive? all
Only
these
on 2-3
20 years?
occasions, my lord, on repeated request, they have paid around 3,000, my
The
lord.
legal aid case you're doing?
My lord, my lord.
Yes, sir. Well, then just issue notice. I heard MSR Datta and the council petitioner issue notice. All respondents
1, 2, and 3.
present in
Managing
is
committee,
present
madam.
except notice on behalf of respondents 1, 2, and 3. Notice to go to the remaining respondents within 3 days as an AD. This after 3 weeks, yes.
Daily list item number 1.
Please, Lordship, my lord.
Oh, yeah, Dr. Turi. What is this?
My lord, this is a disobedience of the division bench order dated 13/10/2023, my lord, which you will find at page 27.
Yes.
My lord, may I read my lord, para 6, next page, my lord, 29, page 29, my lord.
Yes.
My lord, the appellant challenged the essence of by way of two petitions for the 2 different periods. The relevant petitions under 226 of the Constitution were disposed of by holding that the claims for subsidy prior to September 10, 2009, my lord, even if made in case, were liable to be considered, and claims for any year thereafter, if made in case, would not be eligible to be considered for subsidy. However, despite this court holding in the relevant order dated May 3, 2019, the claims made for the previous period, even if disbursed in case, would be considered for grant of subsidy. The relevant petitions were disposed of on the basis of the following operative order. Where minority petitions is disposed of with the direction to the respondent so and so, so and so. This was the direction, my lord. Then Lordship may kindly come to para 7. An appeal was prepared by union to dispose of, since the union repeated in the appeal that the order included in the appeal had already been complied with. The legal effect of this court's order, which attained finality, was that whether or not the claims for the previous period were on the basis of disbursement made in case, they had to be verified, and if found satisfactory, upon verification, the claims had to be honored for the release of the subsidy. However, despite such previous order of this court and the union having accepted this stay by an order of August 2nd, 2019, a substantial part of the combined claim and only principal amount was approved for release. The reason reported in the event was that Madam Chair Notice may kindly see pay first of the relevant order further release date. Since some payments in the first respect of the first half of the 2008-9 had been denied on account of cash payment, the same principle ought to apply for the claims in respect to subsequent period. Clearly, this was contrary to the express pending rendered in the order dated May 3, 2019, in the earlier round of petitions, and which became binding on the parties, including union, upon the union's appeal not being pressed. Then notice may kindly come to page paragraph 10. The union completely misread the order or at any rate acted contrary thereto. The notice may kindly come to next page, my lord, page 32. Paragraph 13.
Yes. So they asked to reconsider. What has happened now, Dr. Tori? They have reconsidered.
Madam, what they have done, Madam, notice may kindly come to annexure 8, paragraph page 53, my lord. And Madam, notice may kindly come to page 57. Again, Madam, they have come to the same issue, whereby notice also that the checklist, what they have stated that, Madam, the checklist, transporters are to be provided for payment of transporter only by check, and that payment made in case are ineligible for encashment. That has notification dated 28 September 2009. The Department of Justice, Policy and Promotion issued checklist A. They are repeating the same thing, my lord. Then, my lord, Lordship may kindly see in view of the above checklist, so and so stated, retrospectively, therefore, as per point 35, it is applicable to the petitioner which is specified the following. Down below, Lordship may kindly see that bank statement for payment of mail transfer during the period payment only by check. They have repeated the same thing, my lord. Considering the fact that the affiliate, a company had not complied in time bound manner instructed by the High Court and failed to submit upon fully required documents support evidence dated 2011-2009 as required under the TSS 1971, which is applicable retrospectively. Again, Mother, they have not negated High Court finding, Mother. As such, the department had rightly taken the decision as per the directions issued by time to time by the Agency Union of India. Then also finally, my lord, what they stated last week, my lord, page 58. Hence, after detailed deliberation, the department decided that applicant Mr. So-and-so claims under the subsidy scheme cannot be accepted as only payment being reflected in the bank statement will be taken into account for transport subsidy scheme is to be granted in 44-point checklist, even though the checklist had been imposed with retrospective effect. And now, therefore, the matter of election claims.
Now, Dr. Todi, you see in which way they have addressed your grievance and said not permissible again. That means it's a fresh. How do you say it's contemptuous?
I got single judge corrected prior to September, the period ended on 31st of March 2009 from 1st of October 2008. This cannot be operated retrospectively. In respect of the clear finding of the single judge being litigated by the vigilance panel, the department again set over the judgment and created obstruction and said that it is not permissible. This is continuous action.
Heard Dr. B.P. Todi, led counsel for senior counsel, is also petitioner issue notice returnable in 4 weeks. Steps are taken within 3 days by the AD. This accordingly and so on. Yes, next.
Item number 2.
May it please your lordships. I appear, my lords, for the petitioner.
Yes. What is this?
My lords, this pertains to termination of a contract, my lords, and consequent invocation of the bank guarantee, which has subsequently been encashed, as also retender process, which has been initiated, my lords. Our immediate concern, my lords, is if I may pass over a list of dates, just for a broad overview of the matter, I'll take my lords to the gist of this, my lords.
This is a HD board. Yes.
My lords, this was a project, my lords. The petitioner, my lords, is a reputed EPC contractor who has had a credible, experienced, my lords, has executed within a time-bound manner projects worth 700 crores or more, big projects of 125 crores, etc., which is why we were found, my lords, credible for award of a contract dated 21/12/2020 by the respondent corporation, my lords. This was for setting up as well as augmenting power stations across 18 sites all over East Garo Hills, my lords. This is a project which was funded by ADB, a large project. The contract was executed, my lords, on 21/12/2020. The project completion, as contemplated in the agreement, was an 18-month period. But my lords will see, right, the contract, the effective date of the contract was a payment of an advance amount, which was in fact about 6 months after the commencement of, after the signing of the contract. So the effective date of commencement of the contract was only on 29/5/2021 when the advance amount was paid, my lords. So what happened is that the project did not really take off in right earnest. The sites were handed over to us as late as 2022, due to which there was a considerable delay because of a lack of cooperation between the corporation as well as the petitioner. So the project, the time was not of essence, my lords will see, right from the beginning there was a lag. However, things came to a head, my lords, when suddenly after a period of about almost 2 years when nothing got done, there was a termination notice that was after review meetings which explored the possibility of taking the matter forward with us. We were suddenly struck, my lords, with the termination notice which was dated 15th of December 2023. But even subsequent to that, my lords, there have been negotiation because my lords will see, we have also annexed the project photographs which show that there's a considerable amount of work that has been done by us. Supplies have been made, civil works have been done. There is a considerable progress, but it has not been completed, and it is due to remission on part of both the contractor as well as the government.
1 second, you said the contract supposed to commence from the date of commencement, actually as per the tender?
As per the as per the contract itself, it was on the payment of the advance amount. So though it was signed on 21.
18 months enter project, 18 months effective date of contract is 29/5/21.
29.
Right.
So though the contract
was. You
was.
say that the project site handed over on 29 June 22. That means a year.
It's not handed over, my lords. It's not.
No,
yeah, the sites.
Your note.
Sites.
That means
yes.
after a year.
My lords, there are 18 sites. So I will page 188. My lords will see there is that when we gave a project progress report in midway of the project, my lords will see contemporaneously we've said that many of the project sites were not made available to us.
Okay, yes.
My lords,
please continue. Yes.
So the last project site, even according to them, was handed over to us only in June 2022.
Okay.
So today, my lords, we are in a situation where there is some completion on our part, and we are before my lords to say that it is possible for us, if we are given some more accommodation, some more time, we are willing to completely complete this project at the same cost that it was given to us in 2020, which is the project outlay, my lords, is 76 crores. We are willing, my lords, if my lords give us some accommodation, to complete the project in a reasonable period, provided there is cooperation from the respondents, my lords. What has subsequently happened is that there is a sudden termination of my contract, my lords. But even after the termination of the contract, there are review meetings held where we come forward and say, these are the problems. You are also aware of the problems. Sites were not given to us. BOQs were changed.
So after you made the request for review, what happened?
My lords, in fact, nothing has happened after that. What has happened is that there is a retender notice that has been given. There is a retender process, my lords, and when we are looking at the retender documents, it's shocking, my lords, that the retender is being done in 3 lots. If I may hand over, my lords, the retender documents which are available publicly seems to suggest that this retender is being done in 3 lots, one of 45 crores, one of 50, because this is something that the state will possibly have to revert back to, my lords. But the project outlay then enhances from 76 crores, where I have undertaken to do it, to about 145 crores, my lords, which is a complete loss to the public exchequer. So I am before, my lords.
What do you want today?
Yes, my lord. There are the bank guarantees which were given by me, my lords. one has already been encashed.
How much is the bank guarantee?
2.25 crores has already been encashed, my lords.
And the second bank guarantee, where's that?
3.32.
Where's that in your petition?
My lords,
It is not an issue, Your Honor. There is no bank guarantee annexed to the petition, Your Honor.
my lords, but they are aware that there is a bank guarantee.
Why you not annexed it to
My
the
lords,
bank?
at that point in time, it was not. Let me hand over, my lords, a document where invocation of bank guarantee, and I don't think that is in
Is
dispute.
it conditional or is it an unconditional bank guarantee?
It was an
It
unconditional.
has to
One
be
was a
unconditional.
performance bank
All
guarantee.
bank guarantees are unconditional now. Yes, just
Yes,
see.
my lords. One was a performance advance bank guarantee. That one has not been encashed, but is in the likelihood of being enhanced any time, my lords, because there is pressure from them. So today I am before my lords that the bank guarantee encashment may be stopped, and as far as the retender process is concerned, my lords, that may not go on. In the meanwhile, let the state come back to my lords as to because if this retendering process is going to cost the state exchequer so much.
We'll do one
and I am
thing.
before
We'll
my lords.
we'll give you a short date. We'll finish up the entire matter.
Very much, my lords, we are willing to commit that if
We can only give you a limited stay with regard to the encashment bank. Yes.
May not,
Yes.
I submit three things, my Lord.
Yes.
First, Your Lordship will kindly see the conduct of the party, because the state has suffered. State has suffered immensely in the hand of the petitioner, my Lord, and in public interest. Kindly see page 182, my Lord. And kindly see the conduct also throughout, my Lord.
Yes.
This is the contract which was to be completed within a period of 18 months. In that light, please 182 million. Please refer to the letter under reference above what is issued to your firm for stoppage of work of this. However, it is regretted to know that till date work in the area allocated to your firm has not been resumed. There has been no communication from your end about resumption of work. This will greatly impact the completion of schedule of the project, for which penalty may have to be imposed on the firm, and contract of 20 million. As such, completion of the package with extended completion of period of 30th June appears to be unachievable. In this matter, kindly recall the office letter of 2nd above and stated that extension is given to you till 30th June without any cost implication and beyond which liquidated damage as applicable shall be imposed. You are submit the reply, Lord. Now kindly see 216 below. 216. It is to inform you that progress review meeting for your package was scheduled on 1st June 2023 via this office email as stated reference. It is regretted to inform you that your management has failed to attend the progress review meeting. On this said date, instead your office has sent a mail on 30th May stating that your MD is suffering from COVID and as such he would not be able to attend the review meeting. It is stated that review meetings are conducted to review the progress of work being executed, and you are and to understand any issue which is hampering the progress of work. As such, any initial belief that management should have other senior personnel attending in your absence has taken cognizance non-attendance. Subsequently, managing director of your firm has committed the meeting that by 6th July for full restraint, my lord. Kindly see these letters after letters we have written to them, and then we have been.
Have you filed affidavit?
No, my lord, notice has not been issued. Kindly see to one more thing, my lord. Now,
Yes.
what they are asking for is stay of the bank guarantee, and on what ground? No
Where's the
ground.
prayer?
It is and kindly see prayer without any reason, not a single whisper that bank guarantee is not issued for the page 40, my lord. Kindly see prayer, page 45.
45.
Yes.
Now, what they are asking for the impugned letter of termination dated 15 December 23 issued by second was an impugned letter of 2nd February 2024. Kindly see December 23, 2nd February 2024, and to directly allow the prisoner to complete the balance work. We have given ample time, enough time. They have not. And 4D, Lord, direct not to encash, Lord. Now, kindly see what has happened in bank guarantee. Also, I just wish to place the facts. We have written to banker of them long time back. They are in collusion with bank, unconditional bank guarantee, and with the collusion of the bank, they are not permitting the bank guarantee to be encashed. And this company, Lord, I have checked on the website. Kindly see one order. Even there are so many checks are bounced. One of the order which my friend will place
of this company house where the prosecution in 138.
No, that's besides the point. Yes, we look only at the now. The dispute is purely contractual. Yes,
My lords,
the dispute is purely contractual.
May
Then
my lords,
what do you
there
expect the red court to do?
there is
Is
a-
there any arbitrariness on the part of the
My lords, may I
corporation?
just- there is a large
We're not
public-
deciding. We're not deciding the matter.
only on the public law, because the retender, my lords, leads to may I hand over, my lords, a judgment which is opposite on the point.
This is a company, my lord.
You are MS Liz
on the
Matthew.
basis-
Yes, my lords.
Right. See, the thing is, talking about public revenue, really also it's
My lords, I will
detrimental to public
demon-
interest.
I've not.
See, this court will examine it. We'll
Yes.
give you 1 week's time.
Yes,
You
my
file a
lords.
short affidavit, and meanwhile, that's the thing. We'll.
My lords,
that
the
we'll-
encashment of the further
and
bank.
it's a contractual matter. I don't know
My lords-
how this court will exercise.
My
Yes.
lords, encashment of the further bank guarantee will be
Yes.
stopped for the next 1 week. I will come before my lords
Yes.
before that.
No, just yes.
May I, my lords, just a judgment which is.
Come and simply file a petition saying that please stay the encashment of bank guarantee.
My lords, may I just hand over, my lords?
It is an independent contract, my lord. It is an independent contract. My friend is here. We will file a reply, my lord, here. If they succeed, we will refund the amount. But if there is a bank guarantee, sanctity will be violated by petitioner like this in collusion with the bank, my lord. It will send wrong message to all contractors and even in all projects, my lord. My concern is this much only. I'm not against this petitioner, my lord.
Yes.
Bank guarantee they are giving. They are
What do you
My
want
lords,
to say?
2
Yes.
points to say. As far as the
Yes.
encashment of the bank guarantee, my lords, there has been substantial performance from me. As far as the performance bank guarantee, one has already been. I am today before my lords saying that if my other bank guarantee is also encashed, it will push me to be a NPA, my lords. It has a repercussion with respect to me. I am seeking a protection.
Where the copy of the bank guarantee? This is not even on record.
It's not a record, my lord. It's not
My lords, we place that on record.
How will we stop the encashment of the bank guarantee? It's not even on record annexed to the
My
annexed to
lords,
the
the
petition.
dates are given. The bank guarantee.
See, that will not suffice. We'll do one thing. You file affidavits. We'll hear it after 1 week.
Well, my lords, in the meanwhile,
Yes.
my lords, they are putting a lot. As
Meanwhile,
far as,
see, the court's hands are tied also.
Well,
We can only say something which is
my lords will then
there.
record.
You know.
My lords will kindly record this bank guarantee and say that
Take
I
down.
will produce it in
Take-
the course of the day, my lords.
Take down. MS. This Matthews, right? With so and
Yes,
so,
my lords.
senior counsel with so and so for the petitioner. Stop. Mr. A. Kumar is present on behalf of ADP is there also on behalf of sponsor 1 to 5. Stop. Notice not to issue to sponsor number 6 presently. Stop. Today, MS Senior Counsel has submitted that due to certain inescapable circumstances, the contract has been awarded to the said petitioner has not yet been completed. Stop. He submits that the petitioner is by compass aggrieved with the notice of termination which have been issued, and also the encashment of the bank guarantees dated. Where are the dates?
There is no date, my lord. There is no nothing.
May I, my lords, hand
Bank
over?
guarantees which have been furnished,
12/1/2021.
which we have furnished to the respondent corporation.
12/1/2021 and
Next paragraph.
29/12/2022.
She praised that in the interim, at least the encashment of the bank guarantees be suspended. Stop. Next paragraph. Mr. Advocate General appearing for the corporation has raised strong objections and submitted that the conduct of the petitioner company does not warrant any interference by this court, and the delay that has been caused has affected what? So delay is caused.
Delay is caused in implementing the project, my lord.
The delay,
And-
considerable delay has been caused in implementing projects which are for public utility.
And will also record my statement that though the contract is of December 2020, projects were handed over to us.
We're not
only
on nothing on merits right now. Stop. Having heard the counsel,
2022,
upon
my
hearing legal counsel parties, it appears the matter deserves further consideration. Stop. Accordingly, the respondents 1 to 5 within 10 days, list immediately thereafter.
My lords, may I hand over? This is the bank guarantee document.
We're not saying anything because,
meanwhile,
sorry,
lords,
if
my
at least your petition should have revealed, at least it should come with the
my
requisite
lords,
documents.
The petition was
We
filed
understand
as
as a council, we understand your
prior.
difficulty. Yes,
May
next
I
matter.
extend this only for
Yes. Right.
my lords? This
Right.
is a letter dated. My lords will kindly see the bank guarantee particulars are mentioned.
You give it
as far
this.
as my lords will if this is reflected in my lord's order, at least till the next 10 days I'm protected, because if this amount, my lords
I'm
will
sorry, we
not
can't
give me a
accept.
stay. My lords will not give me a stay.
Yes, next matter.
Item number
My
3.
lords, one more
Sorry.
submission. My lords,
Sorry.
my lords will
Sorry.
accommodate
You've
me
done
for
your
one more
best.
submission.
You've done your best,
from,
it's fine.
I have come from so far.
All councils are equal in front
My
of
lords
this
will,
court.
just 2 submissions, my lord.
See, we understand your difficulties. Now, at least if you had annexed and at least mentioned the dates of bank guarantees,
Therefore, since
I'm
I
sorry,
have
it has to come in
readily
affidavit.
available-
How do we know what bank guarantee is that?
My lords, they are not
Yes.
disputing it. They are in fact saying exactly
Yes.
the same thing. So
Thank you. Yes, next.
Item number 3.
Yes.
the bank guarantee
Yes, yes.
date is recorded. They may not put pressure that
1 week,
before-
10 days
But
time.
my lords, it's an amount of 3.32
days.
crores, which is
10 days, yes.
we will come
Thank
back
you
to
very
my
much.
lords with our bank guarantee. And I also wanted to show my lords one order where
No,
in
please,
similar-
please.
This is
Please,
my lords-
please, ma'am.
with respect
Your
to
matter's
the-
over.
With
Yes.
respect to
Next
the
matter, yes.
retender, my lords.
Please,
This only
Don't
gives a
drop
way
the
out
please.
to my lords, because
Please, thank
in
you
a
very much.
similar case where the public exchequer
Thank you
was-
very much. You've done your best.
I am obliged, man.
Yes.
I am obliged for the patient here.
Yes.
I'm sorry, otherwise Liz is good friend of mine.
Yes.
All councils
I
are good
was-
friends. It's just
I was hoping that the reasonable approach that we are taking which will be acceptable to of course, a very wise Advocate General.
right.
Obliged.
Thank you.
We'll be back after. Obliged.
Item number 3.
Yes.
Have taken steps against the newly implemented.
What miscase is this one? 268?
This was a petition challenging the patta.
No, what's the miscase?
Implement.
Complete lordship.
Of whom?
Private respondents have
They've been pleaded.
No, Malak, there was an order passed by the Honorable Court to issue notice to the newly implemented respondent. That has been done.
What had happened, lordship, is the erstwhile NOCMA had filed an
You are
objection.
appearing for the new. Who are you appearing for?
4, 3 and 4. Respondent 3 and 4.
Who's 1, 3, and 4?
The deceased, lordship, but we need instructions.
The deceased respondents. How can you appear for deceased people?
Lordship, they had to take steps.
No, he was for the earlier.
He was for the
It was
original.
not-
Now you're for the new people.
His successors. The new.
Have you received notice?
No.
No, they have not received. We have taken steps, Malak.
Your Lordship, we have not received notice in this.
The status shows, Malak, it is still at dispatch. Malak will need some more time.
He's accepting notice.
If he is accepting notice, I have no qualms, Malak.
That's a
We
miscase.
are not accepting notice because they have not come to us, Your Lordship.
Oh, that's a different matter altogether.
That's the only reason.
Yes. Mr. Thapa submits this miscase 68, right?
Yes, Malak.
Yes, that steps have been taken. Steps to stop. However, office note dated 24/7/2024 indicates that service net is complete. So, just after
2 weeks more.
2 weeks await for service report is.
Item number 4.
Items 4 and 5 are connected matters.
We filed today. Today we are in the course of the day we are filing the rejoinder.
Is that for hearing today?
No, it's for filing of orders.
It's orders, man.
So, my lord, after 2 weeks, the pleading will be completed. So, if it is not inconvenient to your lordship, my learned friend, so after 2 weeks it can be fixed for
What's
hearing.
always here, Mr. Das? It's always convenient for us.
No,
It's the senior counsel's inconvenience that has to be looked
No,
after.
court. First, the code of the convenience has to be looked into it.
Doesn't work that way, but yes, Mr. Dita, the senior counsel, also submits that rejoinders are being filed in the course of the day.
Yes.
He praises that the matter be set for hearing thereafter, not objected to by the counsels for the respond corporation or by the respondents. This is a matter of 2 weeks for hearing and so on.
Can it be on 13, my lord? 13, if it is not inconvenient plus my learned friend.
13 won't be a good day because there's a program going on.
Okay,
I will see the retiring also in 2 days' time after that.
Then 12 is okay for you.
No, it will have to be after Independence Day.
It is okay, fine. Which date, my lord, if it is?
We shall give a date
Yes.
after Independence Day.
Item number 6.
Okay. I am deeply obliged.
Because we might have a new CJ coming, so all those things. We are small High Court, is
No,
sort
it's
of
okay, no problem.
work for us.
No problem.
Yes.
No problem.
Yes.
Lordship, I'm appearing on behalf of respondent number 5 and I'm praying for further 2 weeks' time, Lordship, to file affidavit.
It has been sent for signing.
It's for seal and signature, Lordship.
Are you appearing for?
1, 2, 4.
And 6? You already filed it. What's the matter about? Okay, MS Pradhan for 1.5 place for 2 weeks time to file affidavit stuff. Just thereafter and so and so.
Highly obliged, Lordship.
Item number 7.
Your Lordship, I'm praying for some time to file our affidavit in this matter.
You supplied copy?
Yes, Your Lordship.
MS every place. How much time? 1 week?
2 weeks, Your Lordship.
For the 2 weeks time.
Obliged, Your Lordship.
Item number 8.
May please, Your Lord. Your Lord, contempt matter, Your Lord. What has happened in this, Your Lord, that Your Lordship's order is based on the policy decision of the government to regularize the workers who have been in service for quite some time, Your Lord. But all these regulation orders are being placed with the cabinet, Lord. I was seeking some more time to comply with the order, Lord, because the Education Department furnished the detail of the person only on 22nd July
are in process, under process. The pre-response allowed 3 weeks time to come back with instructions.
My lord, we need a longer period, my lord, in this case. 6 weeks,
4
my
weeks,
lord.
yes.
6 weeks, my lord.
Okay, 6 weeks. Or 8 weeks.
8 weeks also, my lord. My lord,
6
we'll be
weeks
very
to come
grateful,
back,
my
come
lord.
with affidavit or instructions, yes.
Item number 9.
Lordship, we are yet to file affidavit in this matter, Lordship. I'm praying for further 3 weeks' time.
Three weeks for a time as prayed, allowed to the respondents for affidavit, yes, thereafter.
Highly obliged.
Yes.
Item number 10.
Item number 10, 11 and 12, they pertain to IBBF matter of Ajanta Hills, my lord. So, my lord, in item number 10, my lord, state is yet to file our affidavit because there were some new developments. New party has filed an implement application. Due to that, my lord, there's a delay here in filing the affidavit. So, my lord, we are hoping that we'll be able to file the next 1 week, my lord.
I'm supposed to file my objection to the
Implement application also, my lord.
Who's asking?
My lord,
the petitioners in
item number 11 and 12 has made an application for implement in
Why
the
have you
present
filed objection
petition.
as yet? Who's the one who's filed application for implement? You are? Who are you? I come. You're a petitioner, item number 11 and
12, my lord.
this is all the same in the command merchant.
My lord.
How long it take for affidavit in 10?
My lord, the hearing matter, it's number 12 has been filed, my lord.
No, in 10?
My lord, 10 we will be able to file in the next 2-3 days, my lord. Apparently, we have already done with the drafting, my lord. We just need to check the documents, my lord. Verify the documents.
R. Golni, on behalf of the respondents number?
My lord, in item number 10, I'm for respondent number 1 to 5.
1 to 5 submits that the affidavit be filed.
No. My apology. 1 and 2. 1 and 2.
1 and 2 submits that affidavit be filed within the period of
1 week, my lord, for both the cases.
Will be filed by 1 week's time. Stop. With regard to 11?
11, I'm 1 to 5, my
11,
lord.
and you're not filing affidavit there. Number 10. Number 10
My lord,
is
number
Hassad
10,
is there,
there are
right?
only 3 respondents, my lord.
I'm respondent number 3, Your Lordship.
Yes.
I'm respondent number 3 in item 10.
Number?
10, my lord.
Who are you?
He is the objector, my lord.
Yes, already filed.
Okay, and then Who else is there in number?
My lord, in item number 10, there are only 3 respondents. 1 and 2 is state, and 3 is Mr. Pala is representing.
Okay, Mr. Pala submits. You already filed affidavit.
My lord.
Submits that affidavit on behalf of number 3 has already been filed. Stop. Then Miss Case 69 is in this case only.
My lord.
Yes, Miss Nata next. Miss Case 69, 2024. That's in the main case. Huh? Mr. ML Nongpure prays that he be allowed further.
I'll have to reply to the state as well. 1 week's time for the objection.
1 week's time to file objection to the impeachment application. Stop prayers allowed. This is matter together with 416 and so on so. Now 11.
In 11, my lord, I'm representing respondent number 1 to 5.
11.
11, my lord.
11, I'm for respondent number 7, Your Lordship.
11, you are 1 to 5. 1 to 5. And then Mr.
I'm for respondent number 7 in 11.
7 and 11.
No, 7 in
Okay, not 11. Then who's for number 6?
I'm for number 6, Lordship.
6, you are Sardar.
Ilaka, Lordship.
You're Sardar Ilaka,
The
okay.
dollar,
Okay, 6. Now pure GA 1 to 5. Then you are for the petitioner.
My lord.
Yes. What's this for today?
Well, we are yet to file affidavits, my lord, here in these matters.
In 11. Okay, all of you not yet file affidavits?
No, my lord.
So in this matter, we list them together with one. Counsels for the respondents, namely MSR Kohli, 1 to 5, Mr. ML Nongpure for 6, Mr. Pasa for 7.
Epala, Your Lordship.
Oh, Epala, sorry. Epala for 7. And who else?
Respondents here.
Pray for allowed further 2 weeks' time to file affidavit stuff. This is the matter together with 416
No, no.
for 2020.
Lordship, one submission, Lordship. In item number 10, the interveners, Lordship, just miss case number 69. They are the petitioners in item number 11.
Yes, yes. We are aware of that.
They have already preferred a fresh repetition, so intervening in my matter.
The more the merrier, yes. And item number 12?
My lord, 12 pleadings are complete, my lord.
Yes, and there is older matter.
However, my lord,
this is matter
they
together.
have filed a fresh, which is why, my lord, which is item number 11, my lord. There's the case of the petitioner is new development has come.
Doesn't matter, we'll hear it together.
My lord, it has to come together.
Item 12, this item 12, this matter together with 416 on next date in the order.
Your Lordship, in item number 12, I am represent respondent number 9.
We'll record that, yes, but listen on the order column together.
I leave it.
Yes.
Give your vote.
Yes.
Hearing, item 13.
Where Mr. Khashing, serious objection.
Counsel is on his legs, Lordship.
No, but what is a settlement talk? This is regarding that shop demolition in. Let's see the file here.
No, my lord, regarding with the land. My lord, can you look to my affidavit of the respondent number 9, my lord?
See, MS Wanyang, order 10.7, he stated that no settlements possible. Then how are your instructions that that's why you're supposed to obtain instructions today? How do you say that settlement is going on?
As instruction, like there was talk of ongoing settlement, but it doesn't result in any positive settlement. Like that's why there's no possibility of settlement. That's why I'm praying that for 2 weeks' time, that this matter may be heard for final.
My lord, if I may be allowed, on the last occasion also I have stated, my lord, there are two things. One is about the civil dispute, and another thing is the development activities. My lord, kindly come to my affidavit on behalf of the respondent number 9. Page para 7, my lord. So para B.
Yes.
Mary, my lord. The village Dorbar immediately convened the Dorbar on the so-and-so and passed a resolution unanimously on the set date by requesting the petitioner to cooperate in bringing the development to the whole village. Here, my lord, after I filed this affidavit, they filed the rejoinder. If I may be allowed to read the rejoinder. Paras, on behalf of the
No, Madam Kharshi.
Yes.
Thing is that only court was just didn't allow John because whether the settlement talks are going on. If no settlement talks are going on, then we'll hear the matter. Once it's senior ready. After 1 week, we'll hear it finally.
Right.
Yes. MS Iwanyang submits that though settlement had been attempted, the same not possible.
May it please the Lordship. May it please the Lordship.
Yes.
Lordship, petitioner is challenging an order passed by respondent EPF authorities. My Lord, order has been passed under 14B and under 7C. Lordship is very well aware.
7Q.
Sorry, my mistake. 7Q. My mistake. Lordship is very well aware. Damages have been imposed through that order.
Penalty and damages.
And interest, my Lord. Interest has been imposed. Now, grievance before this honourable court is a very simple grievance, my Lord. Our grievance centres around the fact that the imposition of damages and interest through the two impugned orders is for a period that stretches almost 25 years back, my Lord. If I can explain, if Lordship looks at the show cause notice, the start of the entire proceedings against me, that is at page 22A. 22A, my Lord, is the show cause notice. If I can draw Lordship's attention to the 5th paragraph. Now the scrutiny of the records, my Lord.
Yes.
Now the scrutiny of the records maintained by this office for the remittances made by you during the period from 1/4/1996 to 31/3/2014. And my Lord, this notice itself was issued in 2021. So the earliest period for which they want us to account for is 11 years back.
96.
Yes, my Lord. The earliest period is 2014.
2014 to 1996 to 31.
So the earliest period, if I can do a quick mental calculation, 2014 is the earliest period, my Lord. So that would be from 2021. That would be 7 years back. So the earliest period they want an account for is 7 years back, and the most ancient period for which I am to produce accounts for is 96. That is about roughly, my Lord, 22 years back. So this is my grievance, my Lord, before this honourable court. My grievance is, I am articulating my grievance, being fully aware and fully conscious of the fact that under 14B there is no period of limitation prescribed.
Right.
Lordship is very well aware of that position of law.
Yes.
But nevertheless, my Lord, I have a grievance, and I will take just a couple of minutes to substantiate and lay out the grievance. Before that, my Lord, if I can take, my Lord, through the mechanical kind of orders which have been passed from time to time by the respondent. After the show cause notice, I entered appearance, my Lord. Then subsequently, my Lord, page 27. Page 27, my Lord, this is a daily order, my Lord. Shri so-and-so, CGM Finance attended the proceeding. He made a contestation regarding the damage period so-and-so and so-and-so. The first stating that because of the area payment due to switching from CDA to IDA, he is directed to bring the requisite documents to support this contention, and as regards so-and-so, he is required to bring the challan along with bank statement. Now, why I'm pointing this out, my Lord, is because one of the main reasons we had given before the respondent as to why this default, if any, had possibly occurred was we had switched from a system of pay scale known as CDA. So because of that switch, there was a massive churning within the organization. Because of the switch, it was our humble contention before the respondent that because of that, in all probability, if there's a delay, it was because of that switch that the delay had occurred. The point was noted, but nothing much came out from that point.
This was as far back as in?
This order, my Lord, was 29/10/2021, right at the top of the 29/10/2021. So soon after the show cause notice, my Lord. Right. Next order, my Lord, page 28.
Yes.
She's
2311.
That is 2311. Dates are not very important, my lord. I'm just showing the way the matter was approached. Shri so-and-so, CGM Finance, attended the proceeding. He submitted a bank statement and challan pertaining to the period so-and-so, wherein he stated that delay was the result of the arrear payment, not the actual delay in remittance. He is directed to submit the office order and bank statement duly attested by the bank manager. So this was the first instance when certain bank statements were required from us. Now, next order, my lord. There was a failure on our part to produce the bank statement. Again, it was reiterated, we have to produce the bank statement. We wrote to the bank. That is Annexure 3, page 30.
Yes.
Now, bank replied to us through this annexure, my lord. Annexure 3, if I can read the reply of the bank, my lord.
Yes.
We refer to your letter number so-and-so, dated so-and-so, wherein you had requested for account statements for the year so-and-so to so-and-so. We regret to inform that as the records pertain to period before the bank was fully computerized, we would require some more time to make the statements available to you. The necessary requests have been placed to our data archival center. The same would be sent to you as soon as possible. This was the response from the bank. Bank was not in a position to give us the statements. And till date, bank has not given us the statements. So authority respondent wanted us to produce bank statements. We asked the bank put its hand up and said, we are not in a position to, at that moment, give us give you the required statements. Till date, statements have not come, my lord. Next page, my lord.
Yes, clarification.
We supplied certain clarifications, not very relevant, but if I'm allowed to read second paragraph. With introduction of EPS 95 pension scheme, corporation liability to pay EPS areas from so-and-so became due. The decision to switch over from CDA to IDA copies enclosed by individual employees took longer period of time, and as such, payment of EPS areas on IDA.
Switch was done when?
This was in 1995, I believe.
So switch 95 was initiated till 21, still not regulated?
No, because the switch takes time because the employees have to opt for that switch. By individual employees, took longer period of time because it is up to the employees to either switch or not switch. So it was a gradual process. Some switched immediately, some took longer period, my lord. Last paragraph, my lord. I'll just skip. As we are already under heavy workload for UAN, Aadhaar, e-nomination, etc., apart from routine work and few working hands, it is not possible at this moment to trace documents of last 15 to 25 years to reconcile the other small figures left in your statement. As such, it is requested to please withdraw the damage charge being very old cases. Now, at this point, my lord, we also started putting our hands up because to dig out from 25 years back was proving next to impossible for us. I said, we are not in a position to dig out those records. Please withdraw these, the charge, my lord. Nothing happened to that. If I can jump, my lord, to page 48. Now, this was a fairly detailed submission we had placed for the respondents' consideration on 25th May 2022. Contents are important, my lord, so I'll just spend a few minutes on this. I'll direct Lordship's attention to para 3, my lord, para 3 onwards. NEPCO has attempted to trace and locate the relevant documents pertaining to the period under question. However, it has to be unfortunately stated that the required documents records could not be traced out, and nor is the same available with the office. This is in spite of all possible efforts having been made in this regard, and has been caused due to the efflux of time resulting in the relevant documents records not being traceable. So, it is once again humbly requested that the charges in respect of damage proposed to be imposed on NEPCO be kindly withdrawn on account of the fact that the information documents now being sought from NEPCO is for a very old period for which it is simply not possible to locate or submit the required information documents. In this connection, with your kind permission, NEPCO wishes to highlight and submit the following for your kind consideration. The facts have been placed in the next paragraphs. Para 4, my lord. No, I'm sorry. The facts are there. They've just been reiterated. Para 5, my lord. Para 5. The aforesaid request has been repeated by NEPCO from time to time, but has not yet been agreed to by EPF Shillong. It is humbly submitted that the said request is one that should be kindly granted by EPF Shillong for the reason that A. The present proceedings conducted by EFPA Shillong relates to a very old period being 15,495 to 13,5/2010. In other words, the proceedings seek to impose penalty for a period as far back as 26 years and with the earliest period being 7 years. As stated, next page, my lord. As stated above, Section 14B of the Act entitles the EPF authority to impose penalty in case of default committed by the employer. More importantly, a bare reading of Section 14B of the Act will show that there is no limitation period prescribed within which the proceedings under Section 14B have to be initiated commence. Therefore, at first glance, the proceedings appear to be valid, even though it
deposit the amounts to the other account and there was a slip up. Maybe there have been some consideration on their part. But since failure to do that from the banks could not produce the records nor from yourself, that means damages have been inflicted upon you.
Yes,
there's no limitation under 14B, and so that the burden is on 14B, and so that the burden is on your shoulders, which you have to bear.
Yes, my lord. As far as the
standing natural justice, arbitrariness, or
Lordship, there are 2 points, my lord. In respect of the appeal provision, there are 2 points. Lordship is very well aware. I will not waste Lordship's time.
Lordship is not aware at all.
Of Whirlpool Corporation, my lord. Whirlpool Corporation says that in spite of the alternative remedy which exists,
right.
in case there is a violation of natural justice and in case the order is passed without jurisdiction. So these are the 2 points that we are placing for Lordship's consideration. To ask for show cause in respect of a period stretching 22, 25 years back is without jurisdiction. I will attempt
unreasonable, you mean?
Unreasonable and without jurisdiction. My statement before this honourable court is that you have no authority to ask me to show cause for a period. So your order is passed without jurisdiction. Number 2, your order is passed by violating natural justice inasmuch as whatever.
And if a judgment is generated on your submissions,
yes, ma'am,
it will set a precedent.
I'm hoping that it does, because the law. I mean, the law.
It's a socially beneficial piece of legislation.
True, madam.
Which that the court always leans towards the plight of the workers.
True, madam.
And so even if if it is on the facts applied to different case, maybe you have a fantastic case.
Right.
When it comes to the rights of it is because they cannot create any kind of loopholes in the system.
True, my lord.
It might be very draconian. They might resort to even the most it's a penal kind of act to recover the dues.
They call it fiscal terrorism, my lord.
Yes, that's a good word. Yes, fiscal. Yes.
So, my lord, I completely understand what's coming from Lordship. I have many obstacles to hurdles to cross, my lord. One being the fact that I'm invoking provisions of a socially beneficial legislation, where the outcome of today's proceeding would be not just on me and department, it would be on a third person, that is the employees, my lord.
Yes.
I completely appreciate that. I bank on certain judgments of the Supreme Court and on different high courts, which have appreciated the fact that there is no limitation period prescribed. But in spite of that, they have said a couple of things.
What are the reasonable restrictions?
My lord.
Okay, continue. What are
Yes, my lord. If I can just.
Sorry for interrupting.
No,
you.
No.
I'm just hearing the.
No, absolutely. Lordship, if you can just finish reading this, because this is my entire case, my lord. So, para C, my lord, at page 51, para C. Notwithstanding the above, and even though Section 14B may itself not contemplate any period of limitation, it would be an unjust and unfair exercise to order for production of documents, etc., for a period stretching as far back as 26 years. In this connection, your kind redeemable. The above judgments, along with some others on the same point, appear to clearly suggest that the exercise of power under Section 14B of the Act has to be within a period of time that can be considered as reasonable by any normal yardstick. A period stretching as far back as 26 years cannot be considered as reasonable by any calculation. In this specific connection, reference is also made to the judgment of the Honourable Madras High Court rendered in so-and-so, reported in so-and-so, where the initiation of action after 5 years was found to be wholly unreasonable. Useful reference can also be made to the judgment of the Honourable Bombay High Court rendered in so-and-so, reported in so-and-so, where the Honourable Bombay High Court has observed on the possibility of serious prejudice being caused on account of abnormal delay in taking proceedings under Section 14B, either because the records, accounts of the defaulter are lost or not available, or because the personnel concerned are no longer available. So Bombay High Court was the first High Court, my lord, where they tried to carve out a certain situation where, in spite of the fact that limitation does not apply to 14B proceedings, that initiation of proceedings after an unreasonable period of time may cause the authorities or on account of the fact that the personnel concerned are no longer available. Naturally, my lord, after 25 years, people retire, my lord. People retire para e, my lord. Applying the ratio of the above judgments to the present proceedings, it is very humbly and respectfully stated that the same have been initiated after an unreasonably long period of time. The said long period of time has also meant that NEPCO is not in a position to supply certain documents as evidenced by SBI letter dated so-and-so and NEPCO letter dated so-and-so. In continuation of the above, your kind attention is also drawn to the judgment rendered by the Honorable Supreme Court in the case of Hindustan Time Limited versus Union of India. This judgment, my lord, my friend is also relying on. This is the judgment, standard judgment, which department relies on in every such case. In this judgment, the Honorable Supreme Court, while appreciating that Section 14B does not contain any period of limitation, went on to formulate the principle of irretrievable prejudice. While explaining this principle of irretrievable prejudice, the Supreme Court has stated that, however, the employer can claim prejudice if there is proof of default and the date of initiation of action under Section 14B. He has changed his position to his detriment. I have changed from CDA to IDA, my lord. To such an extent that if the recovery is made after a large number of years, the prejudice to him is of irretrievable nature. Naturally, my lord. After changing from CDA to IDA, you want me to produce records from CDA. It's not possible for me. I am prejudiced, my lord. He might also claim prejudice upon proof of loss of all the relevant records. Now, I have stated repeatedly, I do not have the records. I cannot locate the records. I cannot prove a negative. If I don't have it, I cannot prove that I don't have it. The best I can do is I can submit an affidavit to that effect, my lord. And or non-availability of the personnel who was several years back in charge of these payment, and provided he further establishes that there is no other way he can reconstruct the record or produce evidence. So there are certain factors, my lord, which Supreme Court has highlighted. First, the office, that is the employer has to show, to get away from 14B, has to show that irretrievable prejudice would be caused on account of the fact that he has changed his position. His circumstances have changed. Number one. Number two, it has to be shown that his records...
Let's elaborate on this.
Yes, ma'am.
However, the employer can claim prejudice,
yes, ma'am,
if there is proof that between the period of default and the date of initiation of action of Section 14B,
yes, ma'am,
he has changed his position to his detriment.
Yes,
what does it mean? Change my detriment. You didn't change your position to your detriment.
No,
you just went from your CDA to IDA.
To IDA. So there was no detriment.
Is it detrimental to the
detrimental
accounts?
Detrimental vis-a-vis the department.
How do you interpret this change his position to his detriment?
Detrimental vis-a-vis the claim raised by the department, my lord. Because now the fact that I've changed from CDA to IDA is proving costly for me in view of the department's claim, my lord.
Okay, that's your interpretation.
Yes, madam. Because naturally, because any change which I effect willingly, I will not affect it to my detriment at any point in time, my lord. So at that point, from CDA to IDA, I went with a conscious decision or with a conscious understanding. It is for my benefit, my lord. But now, after 25 years, in view of the unexpected claim from the department, that change is proving.
What is the amount?
The total imposed amount, my lord, is about 45 lakhs. Not astronomical, but
substantial.
Fairly substantial, my lord.
Okay.
So that is one point, my lord. That irretrievable prejudice has to be caused by the demand that is raised, in view of the fact that I have changed my circumstances. Number two, my lord, I have to show that records are not with me. Number three, my lord, I have to state or I have to show that the people concerned, the officers in charge at that time, are no longer with me. I have stated this repeatedly before the department. Moving on, my lord, next paragraph. A similar concept of irretrievable prejudice has been laid down by the Honorable Gujarat High Court in the case of so-and-so versus so-and-so reported in so-and-so, where it was held that the actions under Section 14B must be within reasonable time or else it leads to irretrievable prejudice. In the last paragraph, my lord, I'll just take 1 more minute on this. In conclusion, we also draw your attention to the latest judgment passed by the Honorable Calcutta High Court in the case of so-and-so, reported in so-and-so, where it has been stated that presence or absence of mens rea, intention, would be a determinative factor in imposing damages under Section 14B of the Act. In the present proceedings, the delay, if any, was caused because of factors like changeover from CDA to IDA, etc., and not because of the presence of any mens rea. So mens rea, my lord, is another factor Calcutta High Court I have highlighted in show cause in this submission. But there are other judgments also which clearly state that imposition of 14B damages cannot be done in a vacuum. First, you have to examine mens rea. Was there an...
I mean, the baseline is the reasonableness.
Absolutely.
And reasonableness of the demand, and also like how does the entities meet it? Has it been caused by deliberate negligence, or has it been caused by other factors which are beyond the control?
Mens rea, my lord. So it comes down to mens rea. Did I intend to cheat or defraud or avoid?
Or to avoid compliance with the Act.
To avoid compliance with the Act. That was never my intention, my lord. That was never my intention. In light of the above, it is once again humbly and respectfully reiterated that on account of the present proceedings being initiated after such a long period of time has resulted in NEPCO being unable to locate the records. I have summed it up, my lord, in the last paragraph. Now, this was my formal answer.
What was the answer given by them?
Nothing. No. The very next order, on the day I submitted this show cause, the very next order, my 21/10/2022, I'll read, my lord. She, so-and-so, secretary of the establishment, attended the proceeding. They are directed to bring the deposit statements of the damage. There is, it was like I never submitted anything. So, subsequent orders, my lord.
Maybe it was never placed before him.
It was, my lord. There's no dispute about that. It was. So, a point is, my lord, finally, page 60. Now, this is the order under 14B. Page 64 is the order under 7Q, my lord. Now, I will not take up lordship's time by going through these orders because I am not on the merits, my lord. My request to this honorable court is to kindly notice at a glance that my stand before the department has not been taken on board, my lord. My extensive show cause, which I have taken lordship through, nothing has been reflected. In other words, I was not heard, my lord.
Where is the record that 29, 10, 21, 2012, 21 in the report?
If I can draw lordship's attention to page 61, last paragraph.
Yeah, Division Kumar.
Yes. Last paragraph, 1, 2, 3, 4, 5, 6, 8th line. 7th line.
Yes.
Next date of hearing, my lord. Lordship has it. Last paragraph in the middle. Next date of hearing was fixed on 25/5 so-and-so. On 25/5 so-and-so, Shri Dujan Kumar, secretary of the establishment, attended the proceeding and submitted a letter, reference number so-and-so, dated so-and-so. And case was adjourned to so-and-so. On so-and-so, Shri Dujan... This is the one-line reference to my defense. That on so-and-so, it was submitted. What happened to it? Have you even read it?
So he means this is a mechanical order.
It is a mechanical order. He had already made up his mind long back, my lord, because there is a one-line reference to my explanation, my show cause, my defense, and that references I have submitted my defense.
Yes.
But what is my defense, and how do you address defense? Absolutely nothing. It's an order passed in violation of natural justice. That is why I'm.
So books for those cases.
Yes.
You cited in your.
Yes, I have a compilation. I'll hand it over, my lord.
Yes.
Lordship will forgive me. It's slightly mixed up. It's not in the order in which I have. Just one more aspect I need to highlight, my lord. Now, failing everything else. Now, number one point being, I am before this honorable court and not before the appellate forum.
Yes, that you have to satisfy.
Because, my lord, number one, as I've hopefully, I'm confident I've managed to convince my lord that this is an order passed in violation of natural justice. That being the case, starting from Whirlpool Corporation, plethora of judgments in my favor, which say that in spite of the presence of alternative remedy statutorily, I can invoke writ jurisdiction. Number one. Number two, my contention before this honorable court is that by imposing damages for a period stretching 22-25 years back, you have passed an order without jurisdiction. Again, Whirlpool and the same plethora line of judgments come to my aid, which say that in spite of alternative remedy of appeal, I can come before this honorable writ court, my lord. So that's one aspect of the matter.
Yes.
The second aspect, and this is my my judgment of my point of last resort, failing everything, if Lordship is in any manner, failing everything, my Lord will appreciate. There are two orders under challenge, one under 14B and one under 7Q.
Yeah.
Damages have been imposed plus interest on those damages. Lordship, that is not allowed. Under 14B, it is deemed that the amount that you are imposing as damages contains interest. A very simple example, if I'm allowed to place before my Lord. I borrow a book from a library, my Lord, a lending library. I'm supposed to return it within a period. I return it after a month, a delay of a month. I have to pay a fine. The library cannot say, you pay the fine, plus now you have to pay interest on the fine. That fine contains everything that I'm supposed to pay by way of recompense. Similar is the case here. I draw Lordship's attention to the compilation, page 24, my Lord. Paragraph 15 of this judgment.
Okay.
1.5. I'll read. We are therefore of the opinion that in system and stamping supra, the division bench took the correct view that damages under section 14B of the Act were inclusive of interest chargeable under section 7Q of the Act, as the present case covers that very period. The respondent had no right to charge the interest under 7Q of the Act additionally when it already stood payable in the order passed under section 14B of the Act, as the petition succeeds on this ground, etc. So this makes it very clear that once you are imposing damages on me, that's a lump sum amount that I have to pay for my sins, so to speak. Now you cannot ask for damages also to be imposed on that amount, my Lord.
There's a full bench judgment.
This is a full bench, my Lord. 1, 2, 3. Full bench, my Lord. 3 judges. And Rajiv Sai Endlo is there. He's a tax expert.
Well, Rajiv Chakder also is there. He's a
True.
also
So,
judge.
as I said, this was my second point, my point of last resort. Failing everything else, my Lord, at least 7Q order has to go. At least I get a relief.
Yes.
At least I get a relief of about 18 lakhs, my Lord, if nothing else.
Yes.
Lordship, this judgment is of Honorable High Court of Delhi. I have to find out whether there is any appeal or not, because the provision says 7Q is there. So whether there is a appeal.
I've done my due diligence. There is no appeal. But for her satisfaction, she can check. But there is no appeal.
Yes, you're not to submit on her behalf.
Sorry, my Lord.
Yes.
I'm not misleading. There is no appeal.
Not submitting on her behalf.
No.
There is submitting.
So, Lordship, I just have to find out whether there is any appeal.
No, but you've heard the submissions.
Lordship.
The thing is that how you have to show the court. Anyway, what do you have to say now? Anything?
Now, the first provision is that this case is not maintainable because there is a provision of going for appeal, which the Act provides. That first they have to opt for appeal under Section 7I. Appeal is there. And irrespective of the fact that the mens rea and also what my learned senior colleague has submitted. Further, in my affidavit, I have already recorded Hindustan Times judgment. In my affidavit, I have already submitted that it seems that whether the registration has made no provision for limitation, it would not be open to the court to introduce any such limitation on the ground of fairness of justice. It is already there in the judgment itself. So, on the ground of limitation, or anything like what my lord.
No, what has been introduced in the judgment is reasonableness.
Pardon, Lordship?
Reasonableness.
Yes, Lordship. So, Lordship, now switching of accounts, that is why the appeal is mandatory, because whatever the defense comes, it has to go through proper evidences, Lordship. If the bank is not in a position, then also the bank authority has to come before the Honorable Court and submit that yes, we are not in a position, we cannot provide all such documents. And also will be on oath and everything it will be a proper evidence. There will be cross examination, and after observing entire proceedings, then the Honorable Court can pass necessary order whether to impose damage on such damaged interest, or whether to exempt them from that. That is why it is very much important that there should be an appeal. And also, Lordship, I would rather say that why they have not gone for appeal is that they have to deposit amount of like 75% of the total amount. That is why they have not gone for appeal, and they have come before this Honorable Court. Before this Honorable Court, they don't have to, if they impose amount.
Yes.
So
I don't deposit an amount now.
I will deposit happily.
Then file the appeal.
No.
You know why?
Yes,
This is beyond this case. It's regarding judicial discipline. Just the other day, exactly similar case.
I am aware of that.
You're aware of that. Yes. The records were missing, FIR was filed, so on and so forth. And so but then finally,
so that was
that
was
finally
withdrawn,
they withdrew it to file appeal.
So that is the choice of that petitioner.
Yes. But luckily, it was not generated in a judgment.
It was.
Would have been
So
binding.
it was a withdrawal simpliciter, my lord, without any finding on any aspect, especially the aspects which I am placing.
You get that tomorrow you come back, or Monday, not Tuesday, with whether there's any appeal. Anything else to say?
Lordship, I have to find out whatever my learned friend has submitted, the judgments, what the appeal part, and also regarding that the judgment which he has submitted, that regarding the
mens rea.
Mens rea, and the mens rea I have already reflected regarding. Just a minute, Lordship. Some of the judgments here I have already gone through, that SSC online, this Jalpaiguri's judgment also, and Madras High Court judgment also. These two judgments, I was going through these two judgments. This also I need to find out whether the appeal is there or not. What is when the case, how the case was initiated, that also I need to find out.
Till Monday, then we will dispose it of. Yes. Otherwise, there's another case, Contempt, which is
only 14B, my lord.
I'd done that case a long time ago.
Okay.
I was for the petitioners.
So I'm hoping that, as Lordship had said, maybe this might be a precedent that.
Yes, it be precedent anyway.
But Lordship, the appeal provision
sometimes
is
the way they act, with due respect to whatever the at the helm of implement such acts, they very draconian. It's just it's like.
But the Lordship, if on last occasion when I was arguing before the Chief Justice, also same thing happened. Lordship was saying that we are in such a middle that the act is there, we cannot go against the act, we have to follow the act, and also the legislation is there where the legislature has passed this act, where suppose now the new code has come up, there is there are some changes in the new codes, but this act, we are also in a very tight compartment, because we cannot go.
Why they say the black letter of the law.
Yes.
Not the letter of the black letter of the law has to be implemented.
We cannot go against the act. We have to.
Yes. No, we're not saying that you're not implementing it. We're just examining it. We're weighing the considerations. We'll give you time till Tuesday. It's a matter of Tuesday.
Monday, my lord. Monday.
Monday will be a bit difficult. I don't think this court will be available.
Very.
19.
There's a matter of further hearing on Tuesday. Just enable the counsel for the respondents to come up with added materials.
This will be 19. I request some time, you will say.
No. How many times you adjourn? This is a 20.
You will see this 23. But here, you will see this petitioner, his Mrs. was sick, and after this, I was not.
His Mrs. is sick?
He was sick, that's why he is not in a position to contact, and after this, I am not getting contact to him.
He's a very good husband, that means. His Mrs. is sick, so he can't argue the case also. What to do? What's the matter about?
Matter with regard to salary, you will see.
Is it connected to other cases? After 2 weeks, due to personal difficulty of the petitioner. And just wait for the request, Ms. Ardem, just a matter of 2 weeks.
23.
May I please, Lordship?
Yes.
Lordship, this matter with regard to the order of the Honorable Lokaita, my Lord has recollect, the at length hearing was conducted, my Lord.
Don't remember anything, yes.
Yes, my Lord.
Fresh.
My Lord, to challenge the order, my Lord, of the Lokaita, whereby the Lokaita has passed the order whereby dismissed the complaint petition, my Lord. In the writ petition, my Lord, the impugn order, if my Lord
yes, now recollect.
Yes, my Lord. Only
complaint against this implementation projects.
Yes, my Lord.
Yes.
Only with regard to the issue left here, my Lord, only that whether writ of certiorari can be issued or not to set aside the order passed by the Lokaita. That is the only limited issue, my Lord. The Lokaita, my Lord, my first argument is, my Lord, the impugn order passed by the Lokaita exceeds the jurisdiction of the statute, my Lord, of the Act, Lokaita Act.
The judgment of the order of the Lokaita.
Order of the Lokaita, yes, my Lord. It violates section 20, subclause 3, my Lord. The second argument is, my Lord, the impugn order, my Lord, passed by the Lokaita is, my Lord, is illegal and exercise of undoubted jurisdiction, my Lord.
Now remember.
Yes, my Lord.
See, is on three things. Now, firstly, I think it was a question of locus.
Yes, my Lord.
Right? Number one. Number two is that you're not aggrieved in any manner.
But I am aggrieved
with the order. And third is that there's no provision for appeal against order of the Lokayukta.
Yes, ma'am. But I am
and fourth
aggrieved.
is a finding of fact.
Yes, ma'am.
And fifth is what else? Anyway, yes, okay.
Yes, my Lord. My Lord, with regard to the agreement, I am aggrieved. I am the person, my Lord, because their corruption happens in the village, my Lord, which is why we filed a case before Lokaita. Lokaita has ordered for preliminary inquiry. In the inquiry, my Lord, report, few projects were not completed, but the wages amount,
have been released.
Yes, my Lord, released to the my Lord VEC, my Lord. So that amounts to corruption, not even started. And in the finding of the Lokaita, Lokaita has recorded that aspect, my Lord. Lokaita has recorded that aspect, that three projects have not yet started, but money has been disbursed from the block development officer. That amounts to corruption, my Lord. Now,
so what kind of order do you expect from this court?
My Lord, at least the matter should rehear, my Lord, before the Lokaita, my Lord. Giving opportunity to all the parties to what amounts to corruption, what is the definition of the corruption, what is called corruption. These are the aspects, these are rehear before the Lokaita. I am not here for rehearing of all these issues, my Lord. Kindly see the impugn order, my Lord.
Okay, let's see.
Yes, my Lord, at page 52, my Lord, in my writ petition. May I read, my Lord?
Yes.
Peruse the preliminary report. Most of the works have been completed as per the preliminary report. However, the following works are yet to start, but the wages amount have been credited to the bank accounts of the job card holders. So and so work have not started, my Lord. Hence, I am satisfied that there is no prima facie case of corruption against the public servant report, and the case is disposed of as follows. Number one, the Community and Rural Development Department shall cause an inquiry regarding the payment of wages to the job card holders when the work have not been started as mentioned in the preliminary report, and take action accordingly. The proceeding is hereby closed. My Lord, now how this the impugn order is violated section 20 subclause 3. For that, my Lord, I will refer the Act, my Lord. Kindly have the Act, my Lord. The Meghalaya Lokaita Act, my Lord, 2014, section 20, my Lord.
Yes.
Section 20, subclause 3, my Lord. But we filed the complaint petition under section 20, clause 1. So,
section
20, my Lord. Provisions relating to complaints and preliminary inquiry.
Of the Act?
Yes, my Lord, of the Act.
Section 20?
Yes, my Lord.
1 second.
20 subclause 3, my Lord. May I read, my Lord?
One second. Yes.
Yes, ma'am. Subclause 3, my lord. A bench consisting of not less than 3 subclause 3, my lord. A bench consisting of not less than 3 members of the consider every report received under subsection 2 from the inquiry wing or any agency, and after giving an opportunity of being heard to the public servant, decide as to whether there exists a prima facie case and make recommendation to proceed with one or more of the following actions, namely: number 1, investigation; number A, investigation by any agency; number B, initiation of the departmental proceeding or any other appropriate action against the concerned public servant by the competent authority; number C, closure of the proceedings against the public servant. Now, interestingly, in the impugn order, two things happened, my lord. The first hand, the Lokaita has stated that I am satisfied there is no prima facie case. But
Yes.
on the other hand, the same Lokaita has stated in their order that the work so and so has not yet started. Money has been disbursed. In the third aspect, going to that extent, Lokaita has directed that inquiry should be initiated against the block development officer. So now there is a contradiction in the order, my lord, in the impugn order.
How?
My lord?
Because contradiction, you're saying he has not detected any corruption, prima facie.
My lord,
correct,
no.
he has not detected corruption.
Yes,
only fact that has been detected is that works have been started, but the amount has been given to the credited to the account of job card holders.
Yes,
and the only direction given is that, okay, works are done, how is the amount transferred? That's all.
So now question...
Did not, you know, like...
a reasonable question arise, my lord, from that order.
Imputing any allegation that there's been corruption.
Now question...
So the money is gone to the job card holders.
Yes, my lord. Whoever may be, job card holder, secretary, president, whoever may be, that money is a public money. That money cannot go, my lord, without accountability, my lord. The money will transfer after work, after finishing of the work, my lord. After finish of the work, the master roll will submit to the block development officer. Then they will enter into this the MIS. Then BDO will verify all.
MIS?
MIS, their system, my lord, in the computer system. There is a system, my lord, in the computer. I am not able to recollect the full form. Management information system, my lord, in the block development officer. So after due verification, BDO, concerned BDO has to affix the signature, then the money will transfer, my lord. So now question comes, without started the work, how money has been transferred? And money are already they have siphoned by the every job card holders in connivance with the president, secretary and the block officials, my lord. So that amounts to corruption, my lord. That amounts to, there is a serious corruption, my lord. So now Lokaita has failed to appreciate that aspect. I come before lordship with only with the direction to the Honorable Lokaita to rehear the matter, to appreciate that vital aspect of the matter, my lord. I am not here for the appreciation of the evidence here, my lord, because this court, I am well aware, my lord, this court is not sitting as an appellate jurisdiction, my lord. If the order of tribunal or lower judiciary, on the face of it, it is illegal, then this honorable court has enough power to issue writ of certiorari to set aside or direct, my lord, or exceeds the power of the, or exceeds the power which is enumerated in the statute, my lord. This honorable court has enough power, my lord. And same happened, my lord, in Jharkhand. I have submitted, my lord, one judgment, my lord, in the same way, my lord. But I have submitted, my lord, Jharkhand. Yes, my lord, I have submitted before your lordship, my lord. 2022 SCC online Jharkhand, my lord. My lord, last occasion I have submitted, my lord.
Oh, yes.
Yes, my lord. In that, my lord, para 38, my lord. Yes, my lord. Para 38. This honorable court is well conscious of the settled position of law regarding the issuance of writ of certiorari, which is having limited scope, as has been held by the Honorable Apex Court in the case of Syed Yaqub so-and-so, reported in AIR 1964 SCC 477, wherein para number 7, their lordship have held as follows. The question about the limits of the jurisdiction of high courts in issuing a writ of certiorari under 226 has been frequently considered by this court, and the true legal position is that behalf is no longer in doubt. A writ of certiorari can be issued for correcting errors of jurisdiction committed by the inferior courts or tribunals. These are cases where orders are passed by the inferior courts or tribunals without jurisdiction, or is in excess of it, or as a result of failure to exercise jurisdiction. A writ can similarly be issued where in exercise of jurisdiction conferred on it, the court or tribunal acts illegally or improperly. As for issuance, it decides a question without giving an opportunity to be heard to the party affected by the order, or where the procedure adopted in dealing with the dispute is opposed to principle of natural justice. There is, however, no doubt that the jurisdiction to issue a writ of certiorari is a supervisory jurisdiction, and the court exercising it is not entitled to act as an appellate court. This limitation necessarily means that the finding of fact reached by the inferior court or tribunal as a result of the appreciation of evidence cannot be reopened or questioned in writ proceedings. An error of law which is apparent on the face of the record can be corrected by a writ, but not an error of facts, however grave it may appear to be. I am on that, my lord. Error of law, my lord. In regard to a finding of fact recorded by the tribunal, a writ of certiorari can be issued if it is shown that recording the said finding, the tribunal had erroneously refused to admit admissible and material evidence, or had erroneously admitted inadmissible evidence which has influenced the impugned finding. Similarly, if a finding of fact is based on no evidence, that would be regarded as and be corrected by a writ of certiorari. In dealing with this category of cases, however, we must always bear in mind that a finding of fact recorded by the tribunal cannot be challenged in proceedings for a writ of certiorari on the ground that the relevant and material evidence adduced before the tribunal was insufficient or inadequate to sustain the impugned finding. The adequacy or sufficiency of evidence lead on a point, and the interference of fact to be drawn from the said finding are within the exclusive jurisdiction of the tribunal, and the said points cannot be agitated before a writ court. It is within three limits that the jurisdiction conferred on the high courts under 226 to issue a writ of certiorari can be legitimately exercised. Yes, my lord. My lord, next para is 39, my lord. The 39 is more important, my lord. I'll read the inverted comma portion. With regard to the character and scope of the writ of certiorari and the conditions under which it can be issued, the following propositions may be taken as established. Number 1, certiorari will be issued for correcting errors of jurisdiction, as when an inferior court or tribunal acts without jurisdiction or in excess of it, or fails to exercise it. Number 2, writ of certiorari will also be issued when the court or tribunal acts illegally in the exercise of its undoubted jurisdiction, as when it decides without giving an opportunity to the parties to be heard, or violates the principle of natural justice. Number 3, the court issuing a writ of certiorari acts in exercise of a supervisory and not appellate jurisdiction, my lord. But I am on number 1, my lord. Correcting errors of jurisdiction, my lord. But in this case, my lord, the Honorable Jharkhand High Court has set aside the order of the Lokayuta and directed the Lokayuta to, my lord, to rehear the matter, my lord. With regard to the power of issue of the writ, my lord, I would like to submit another judgment of the Honorable Supreme Court. My lord, para 14, my lord, in that judgment, Honorable Supreme Court judgment. 2023 SCC online, SC.
Para 14.
Yes, my lord. Para 14, my lord. Yes. Page 435. May I read, my lord? A writ of certiorari is to be issued over a decision when the court finds that the process does not conform to the law or statute. In other words, courts are not expected to substitute themselves with the decision-making authority while finding fault with the process along with the reasons assigned. Such a writ is not expected to be issued to remedy all violations. When a tribunal is constituted, it is expected to go into the issues of facts and law, including a statutory violation. A questions as to whether such a violation would be over a mandatory prescription as against a discretionary one is primarily within the domain of the tribunal. So also the issue governing waiver, acquiescence and estoppel. We wish to place reliance on the decision of this Honorable Court in Hari Vishnu Kamath versus Hayat Ahmed, 1955, Volume 1, SCR, page. Then the question is whether there are proper grounds for the issue of certiorari in the present case. There are considerable arguments before us as to the character and scope of the writ of certiorari and the conditions under which it would be issued. The question has been considered by this court in Perry and Company versus Commercial Employee Association, Madras, 1952. So and so, my lord, these are the cases, my lord. At quite recently, in the next page, my lord, so and so case, 1955. On these authorities, the following propositions may be taken as established. Number 1, certiorari will be issued for correcting errors of jurisdiction as when an inferior court or tribunal acts without jurisdiction or in excess of it or fails to exercise it. Number 2, certiorari will also be issued when the court or tribunal acts illegally in exercise of its undoubted jurisdiction as when it decides without giving an opportunity to the parties to be heard or violates the principle of natural justice. Number 3, the court issuing a writ of certiorari acts in exercise of a supervisory and not appellate, my lord. My lord, with the judgment, my lord, this court, honorable court, my lord, has enough power, my lord, to when the impugn order exceeds the jurisdiction of the act, my lord. I'm not on. I'm not on the finding facts, my lord.
Yes.
So finding facts left with the, my lord, the tribunal, left with the, my lord, Lokaita, my lord. That aspect will decide by the Lokaita after giving an opportunity to all the parties. Prima facie, it looks, my lord, the Lokaita has done an error, my lord.
See, Mr. Hassan, the thing is that in 226, we're not reappreciating any evidence.
My lord, I'm
looking at bare illegality.
Yes, my lord. Yes, my lord. This impugn order, my lord, suited, my lord, has what, my lord, comes from my lord, falls from my lord.
Illegal.
Yes, my lord. Because kindly appreciate this aspect, my lord. 3 component, my lord. The Lokaita, my lord, admitted that aspect. The 3 projects had not started, and money has been now.
Illegal in the sense that he let him off the hook. You mean to say that without asking for further action, without seeing that your arguments, you see, Mr. Hassan, to convince this court, it is that there was corruption.
Yes, my lord.
The Lokaita failed to see it.
Yes, my lord.
He said there's no prima facie case and asking for an inquiry. So you're asking this court to reappreciate this finding of fact by saying that the Lokaita, in appreciating the materials before it, had failed to exercise jurisdiction in much as a blatant case. But can we reappreciate that? We not review the evidence or whatever is placed before it and the findings?
May I, my lord? What, my lord? My lord, if the Lokaita had not recorded that finding, then the question, then the second part will my lord, then the second part, my lord, what comes from my lord, then we have to appreciate from the inquiry report, my lord. I am not on inquiry report.
Now can we substitute our findings for the finding of Lokaita?
Then Lokaita on, I don't know what's in that position when the order was passed.
See, we're not dealing with an order of an executive authority, where the parameters of challenge are very, well defined. He has ordered Lokaita, and the things that we're not setting the appeal, number 1. Number 2, you're asking for excess of powers of for quashing. Number 3, even asking the court to substitute its findings, and give its own findings that why it is wrong to base. That means we are going to substitute own findings. That the Lokaita coming to a prima facie satisfaction that if there's nothing, and with inquiry is wrong. So that's the only thing that you see. This court also wants to give you relief. Yes. That may be something wrong, but the what do you call it again? Sitting in 226 and exercising great jurisdiction, we asking for such URI.
My lord, yes, my lord.
That's the thing.
three components in the order, in the impugn order, my lord. I am still repeating on that, my lord. Because, my lord,
but we cannot
I am also failed to understand.
Yes, we feel understand. So we cannot substitute our findings or a finding locuyucta. Because we are not sitting in the appeal.
We are not finding of facts.
We appreciate evidence.
We are not finding of facts.
It's not a first appellate court.
For finding of facts, we have to peruse the inquiry report, my lord. We are not on that. Simply, my lord, everything is correct. Perusing the impugn order, my lord. We are not on finding of facts, my lord. For finding of facts, we have to read.
We're not going to question the finding of facts.
Yes, my lord. My lord, it looks prima facie, my lord, exceeds jurisdiction. It looks prima facie illegal, my lord. Then what amounts to corruption? That question needs to. There is more interestingly, the Lokayuta is a special body constituted to look after the corruption, my lord. So if Lokayuta, my lord, in the honorable in the
there's no provision for final review for Lokayuta.
No, my lord. No provision, my lord.
But off the record, my friend has
review. I mean, it can't be a review.
Off the record, my friend has another remedy which I might share at the end of proceedings. To writ petition cannot lie, my lord.
No, my lord. I beg to differ, my lord, my learned senior, my lord. The Honorable Jharkhand High Court has did the same thing. Issue writ of certiorari and set aside the order. Directed the Honorable Lokayuta in Jharkhand to
let's see the facts of the case.
Yes, my lord.
In fact, my lord, para 43, that explains why Jharkhand High Court intervened. Para 43. Para 43, yes. This court, making the principle laid down by Honorable Apex Court applicable in the facts by taking into consideration the fact that even though the writ petitioner has submitted her reply, but there is no consideration, then the question is that why the petitioner has been called upon, etc. There was a violation of natural justice. She was not heard. So if there is a violation of natural justice, if there is an error of jurisdiction, if the judgment is palpably erroneous, 226 applies.
Three components. Again, I come to 2023 judgment. Three components. My learned senior has on one component violation of principle of natural justice. My case is on another footing. Number one, exceed jurisdiction. Is it not exceed jurisdiction? My lord, the impugn order. Section 20, clause 3, the Lokayuta has the power after receiving an inquiry report, preliminary inquiry report under section 20, subclause 2. Then power comes under subclause 3. After receiving the preliminary inquiry report, the Honorable Lokayuta has to decide first whether there is a prima facie case or not. That is first. If they decide that there is a prima facie case, want to go ahead, then three options. Number A is investigation. Number 2 is departmental proceeding against the officers. 7, yes. Number C is closure of the proceeding, my lord. So now, interestingly, in the impugn order, my lord, three components they have held. First, they said the so-and-so work order has not been started, money has been disbursed. Number second is, I am satisfied there is no prima facie case. Third is, he go on to direct the officer, higher authority to initiate inquiry against the block development officer. So now is it not amounts to violation of the exceed the power under the statute? So if I have to again agree with him, my lord, on that issue, para 43, my lord, Jharkhand judgment on violation of principle of natural justice. Jharkhand High Court had set aside. Now on the same issue under subclause under point 1 of 2023 judgment of violation or exceeds the jurisdiction, this honorable court has power invoking 226 issue writ of certiorari to the Meghalaya Lokayuta.
Yes.
To rehear the matter.
How you aggrieved?
My lord, I am for the corruption, my lord. I am the person from that village, my lord. Corruption, as per my lord, my contention, corruption happened, my lord. Which is why I come before the Honorable Lokayuta by filing a complaint petition. So my complaint case has to be heard, my lord, legally, my lord, as per the act, within the four corners of the act, my lord. That is my only case.
Yes.
My lord, my humble prayer, my lord, kindly set aside the order, my lord, to issuing a writ of certiorari and direct the Meghalaya Lokayuta to rehear the matter, giving opportunity to all the parties, my lord. That is my respectful submission, my lord.
I'll be very brief, my lord, because Lordship has seen what is the weakness in petitioner's case. Petitioner wants the matter to be remanded back because, according to petitioner, order is wrong. And order is wrong, according to petitioner, on facts, because the preliminary report might have said something else, might have indicated a different picture. Lokayuta misappreciated that picture and passed this impugned order. Now, just to reiterate what I had pointed out on the last occasion, impugned order, my lord, is in two parts, Lordship has seen. First part is the finding of the Lokayuta that there is no prima facie case. That is a finding in exercise of power under section 23 of the Act.
Yes.
And more importantly, it is a finding on fact based on the contents of the preliminary report. So,
where's the preliminary report? You got a copy, no?
Yes, my lord. In the writ petition,
annexed.
Annexed. Last occasion, my lord has gone through the entire report.
Forgot about it. Yes.
Yes, my lord.
So.
Oh yes.
Yes, my lord. So the first part is on facts, a finding on facts. Now, obviously, and I think admittedly also, there cannot be any interference, with all respect, my lord, from this honourable court as far as the first part is concerned.
Yes.
If the first part cannot be interfered with, the first part to the effect, in respect of the second part, the grievance my friend has against the second part, his grievances, this is beyond by the second part. He cannot be, my lord. Who is the person aggrieved by the second part? The private respondent.
Who is the private respondent?
Mr. Sheikh.
That is also direction is not against me, Lordship. That is the job card holders.
Exactly.
Direction is against the officers in the block.
In any event.
Okay. The direction is
Not even for you. In any event, in any reading of the matter, petitioner cannot be aggrieved by the second part. So that is where we are, my lord. The impugned order is in two parts, and both are not, they don't flow one into the other. One can be carved out. So if honourable court, leaving aside the fact that he, on the face of it, does not appear to have the jurisdiction or the power to, or the locus to challenge the second part, if lordship comes to the conclusion that second part of the order is beyond the scope of 23, section 20, subclause 3, then second part can be struck off, can be done away with. It is for his benefit, but the petitioner appears to be expressing a grievance against the second part. If it is found to be without jurisdiction, if there is to be an error of jurisdiction,
the only thing he's got to hold on, you want to take that away from him also.
The second part can be done away with. I'm prepared to make a statement at the bar that.
No, in fact, I am agreed with the other part also with regard to the corruption part. That is my case.
So I'm just coming to that. So if the second part is found to be an error of jurisdiction, it can be struck down. But the first part remains. Then we are left with the first part. Now my friend is saying he has a grievance with the first part. What can his grievance be? That the first part is wrong, that there is actually a prima facie case. And based on what can the petitioner say that? The inquiry report. So therefore, for this honourable court to remand the matter back, but honourable court will have to agree with him that yes, there is actually a prima facie case. For honourable court to come to the conclusion that yes, there is actually a prima facie case, honourable court will have to dive into the facts, my lord. And honourable court, again with respect, my lord, cannot and should not do that exercise in under which jurisdiction. Just two more points, my lord. On the last occasion, I had submitted a judgment, my lord. That is a 2023 judgment of the Supreme Court. That is Central Council for Research versus Bikartan.
What does it say?
Lordship, on the scope of writ jurisdiction. So, certiorari. So what it says, very well-established principles, my lord, have been reiterated. Number one, if the statute does not provide for a provision of appeal, writ jurisdiction cannot be invoked to circumvent that absence. Lokayuta Act does not have a provision of appeal. By filing a writ, you cannot hope to circumvent that absence of appeal, my lord. Number one. Number two, this judgment reiterates that an error of law can be corrected. And an error of fact, no matter how erroneous, and that's the exact language used, no matter how erroneous, cannot be interfered with in writ jurisdiction. So even if Lordship takes the trouble of examining the inquiry report upon my friend's insistence and coming to the conclusion that yes, actually there is a prima facie case, and Lokoyukta was wrong in holding that there is no prima facie case, even if Lordship's mind comes to that conclusion that there's an error of fact, no matter how erroneous that error of fact, with respect again under 226, there can be no interference. So in any reading of the matter, my lord, this would not be the correct forum. This would not be the correct forum to seek quashing of the order. No case has been made on, my lord, because it all comes down to the facts.
So where should you go then?
The option stares my friend in the face. It's a very easy option. Instead of fighting the law, in fact, my friend is faced with the law. He cannot fight the law. So the law does not allow this Honorable Writ Court to exercise jurisdiction.
That's the only hurdle, yes.
My lord, with regard to my senior has submitted with regard to the facts part, the last occasion my lord has perused the inquiry report. In the inquiry report, whatever the Lokaita has held in the impugn order is correct, my lord. Those projects were not started and money has been to the accounts. So now my learned senior has in their affidavit has failed to give their reply on corruption part. Now I am not on that key like facts, my lord. Now they have recorded in the impugn order. That is the vital question here, my lord. The second part is they have exceeded the jurisdiction. The first part, the so-and-so has not started. Money has been transferred. That amounts to corruption. That amounts to corruption, my lord. And that is a specialized body to deal with the corruption. And if this honorable court, my humble understanding, my lord, this honorable court has enough power, my lord, under 226. If something goes wrong in the lower judiciary or in the tribunal, my lord, this honorable court has equipped with enough power, my lord, to issue writ, my lord.
That's it. Yes.
As far as my friend's insistence that there is corruption and therefore there should be judicial intervention, Lordship, this is writ jurisdiction, my lord. In a PIL, maybe that would have my friend would have standing to enter the court and invoke jurisdiction on that ground alone.
On the face of it, in the judgment, on the face of it, if it is on the face of it erroneous, illegal, this honorable court has power. It looks it's illegal, my lord. It looks illegal, erroneous, my lord, on two aspects. One is jurisdiction, and another is, my lord, on the first part, my lord, recording of the corruption part, my lord.
Yes.
Lordship has a copy of this judgment, 2023 SCC online. Others I can supply a copy. I had supplied a copy last time. 2023 SCC online, Supreme Court 996.
Okay. Yes.
Okay.
Para?
Para 51, 54, 55. I can give a copy if required.
Okay.
Should I handle?
No, it's fine. 223 SCC online 435.
Yes, ma'am. SCC online SC 996. 2023 SCC online Supreme Court. 2023 SCC online.
What is your 23 SC online 435 is judgment?
Yes,
Your
ma'am,
judgment?
that is mine one, my lord.
Para 14.
Para 14, my lord.
That is.
Oh, sorry, yes.
435. Well, all this I perused the same, my lord, the same in my judgment, in my senior judgment also, the same principle, my lord. From, my lord, that case TC Basappa versus T Nagappa, from that, my lord, the Honorable Supreme Court has the same principle on three issues, my lord. The writ of certiorari can be issued on the same issue, same principle.
Yeah. What's our judgment? You said Jharkhand.
That one, other is, my lord, Jharkhand High Court, my lord.
Yes. That's
Jharkhand.
para?
Para, my lord, 38, 39, 40 and 43, my lord.
Sorry, 39?
40 and 43, my lord.
So,
What the Natural Justice is?
43, Jharkhand, my lord, has been passed in a very specific fact situation, violation of natural justice.
Yes.
That is also come under the same principle, my lord, natural justice, my lord.
Okay. Should we reserve it or pass judgment? Oh, sorry, Mr. Sheikh. I'm so sorry. Yes. We can't shut you down. What do you have to say? Yes. Come this side.
So far as other issue is concerned, Lordship, that facts as well as principle of natural justice is concerned, Lordship, I am not on that. What my friend is harping time and again saying that there was a jurisdictional error, Lordship.
Yes.
That is his main point. Now, Lordship, jurisdictional error will come when, Lordship?
Yes.
Section 20 of the Lokayukta Act says if upon perusing the preliminary report and after hearing the parties, if the Lokayukta records prima facie satisfaction that something is there in the inquiry report, then some sorts of misappropriation or corruption has taken place, then only the three options will come, Lordship. One is investigation, another is initiation of departmental proceeding, and another is closure of the proceeding. Now here, Lordship, what happened? Here the Lokayukta has recorded the prima facie satisfaction that no case is made out against the public servant. That is why the Lokayukta has closed the proceeding, Lordship. Close the proceeding. Now, where is the jurisdictional error, Lordship?
No. You see, what has been argued is that if it closes then well and good. But he has gone beyond that and asked for inquiry to be done against the BDO.
Lordship,
that is why.
Yes, true.
Because the finding was that money had been transferred to the account job without the work being started.
Yes, ma'am.
So Ms. Hassanski is that if it stares you in the face that for something that's not been done, money has been paid, what more do you need than to initiate proceedings against the BDO or whatever?
True, Lordship. Now again, Lordship, who is he, Lordship?
No, fine. You're still a jurisdictional error.
Yes,
You argue on that.
Yes.
Yes. Now you say section 20.
Now my learned friend, he is submitting my locus. He has no affidavit on record. That is one aspect.
You didn't file affidavit also?
No, Lordship.
Why?
Second aspect, on 16/4/2024,
Why didn't you file affidavit?
my lord has passed an order whereby ex parte order was passed. He has not challenged that.
My
one
lord,
also.
when I entered appearance, Lordship, the matter was heard, Lordship, from my learned senior was arguing on behalf of the Lokayukta, Lordship. Then the matter was, we can say...
Hearing stage.
Yes, hearing stage, Lordship. Then subsequently the hearing was deferred, Lordship.
He was duly issued, affidavit of service was filed, my lord. He entered
I
lately
endorsed the-
expert.
Oh, so you only heard, no more filing.
Without
of-
affidavit,
no
whether
more
he
filing
can
of
raise all
statement.
this maintainability issue, my lord. He could have filed his affidavit, maintainable, who I am. I could have answered.
He's been banned from filing affidavit, I think.
Yes, my lord. Now he cannot argue on that point, my lord.
I have...
So we record all submissions of
That is the only aspect. Now the Lokayukta has the power.
Power
it is not
has to
that
use
it is,
strongly, my lord.
Lordship will kindly appreciate one thing. Had there been a prima facie satisfaction that yes, corruption has been taken place, and after that, despite having three parameters, if the Lokayukta, fourth direction, then he can say that he went beyond the jurisdiction, Lordship, because the direction were not within the three principles set out in the Act. Then he could have raised the issue that yes, there is a jurisdictional error, Lordship. Now it is not a case. It is not a case. Here the Lokayukta has recorded the satisfaction that there is no prima facie case. Now the satisfaction, if that was not there, then if the satisfaction was otherwise, then if the Lokayukta given a different direction beyond the jurisdiction of 3 parameters here, Lordship, then my friend could have raised
Without
the issue.
jurisdiction.
Yes, that he exceeded the jurisdiction, Lordship. Now it is. Now the direction is given, Lordship.
Has argued is that the order is contradictory also.
Yes, ma'am.
One hand, if finding no prima facie case, other hand, other hand, you've taken action under 20, you should have closed it. Other hand, you still asked for a inquiry to be done. So that is why he's saying that this order is not within the meaning of section 20, and so it's without jurisdiction. He should be clear in his mind.
Yes, that is true, Lordship.
Other
That's
part
true.
also,
That I got
Honorable
it.
Lokayukta
Right,
himself
that's what
recorded.
he's saying,
Then I got
recorded. Recorded.
But then, only one thing, Mr. Hassan, whatever the facts may be,
no, my lord,
your main hurdle is the applicability of law and the past excessive court under 226
my lord has to appreciate,
deal with such arises. So
my lord,
again, we'll repeat that we can't go and uncover finding of fact.
The tribunal or the inferior courts, my lord, if there is in the statute, if it is there, my lord, prima facie, some criteria has to be there, my lord. That order has to be reason order, my lord. Prima facie, I am satisfied. That is not enough, my lord. On the other hand, it reflects in the impugn order, my lord.
Okay, anything else?
Lordship, that
needs inquiry, my lord.
so far as the jurisdictional error, Lordship, that is my submission.
There is an expertise order, my lord. There is no affidavit on record.
No, after he can apply CPC, even though it's a statement, but he can advance his arguments.
Even if I am not party, also I can intervene, Lordship.
With the leave of this honorable court only.
Anything else, General?
No, that's all. My friend had made a very interesting submission on the fact that, the bottom line of the submission is these two portions of the order they exist by themselves. So one has no connection with the other. If Lordship finds that the second part, where
it's contradictory,
where the second part may be beyond the scope of the statute, that can be done away with, my lord. But the first part can still exist without the second part.
He wants the second part to exist and the first part be
Exactly.
My lord, it seems prima facie when the corruption happens, my lord.
And as far as my friend's submissions, the fact that the matter is ex parte, Lordship is aware, my lord, Swaran Singh versus Election Commission, he can submit.
He can make submission. That's what we expressed last time.
Yes, ma'am.
Yes, hearing concluded, judgment reserved.
26.
Interesting case.
Yes, ma'am.
Item 26.
None appear the petitioner. Dismissal default list after 2 weeks.
She's there through VC.
No, she's not a petitioner.
For the respondent, after 2 weeks.
No, the other one. Not sure.
Where?
The petitioner is also appearing.
She's also there.
Where is she? Yes. Counsel for precious absent on call, list after 2 weeks.
Published.